Excellencies, ladies and gentlemen, colleagues and friends, I'm of course very honored to be here and happy that I was invited. I get a little bit shy when you speak about the Icelandic view. It is obviously not the official view of Iceland that I'm going to represent, but I'm going to reflect a little bit on what I call the outer limits of the EEA and current challenges, and I will have an outlook from Iceland for sure. Well, we have discussed now quite a lot the sort of challenges that we see and these geopolitical strong winds and currents, and how is the EEA agreement faring in all of that. That is a little bit my starting point, and I tend to see things constitutional. Maybe it's just me, can't help it. But when discussing the EEA agreement, I always look upon this agreement consisting at least of these three pillars that have to do with the agreement itself, the structure, etc. And then it's the EU side and certain EU constitutional issues, and then, of course, also the national constitutional issues. And then I'm not only talking about Iceland, of course. And hopefully towards the end, I need to check the time. I can have some reflections or outlook. And I brought with me one case from the EFTA court, printed here in full. You will see. As we all know, or most of us, I guess, the EEA agreement is static. And we have this ever-widening gap. We have already this morning be discussing a little bit the possibilities of extending and amending the agreement with these, as Andrea mentioned, the small international agreements, and that are the decisions of the Joint Committee. Now, Protocol 31 has been mentioned. That is what is covered by Article 78 and 79. Article 118 is the amending of the agreement itself, perhaps the least relevant of these listed, and Article 1.2 is, one could say, the main ambit of the agreement as such. I just wanted to stop a little bit and reflect on textual interpretation of Article 102, which is the main sort of article for amending the agreement. And it was also, I think, mentioned here by Pascal earlier, how seriously do you take the scope of the EEA agreement, and where do you start when you are assessing as whether something is falling within the scope of the agreement or not. And I think there has been a tendency from the beginning to be a little bit conservative here for different reasons, mainly from the EEA side, and being skeptical sometimes when something had been labeled EEA relevant, obviously not as a general rule, but we have cases of that nature. But now things have shifted, and I think it is extremely important to take seriously the main aim of what is mentioned here in Article 102, namely that the Joint Committee, and this is in order to guarantee legal security and homogeneity. That is the starting point of all of this, and that is what the Joint Committee needs to consider when considering amending the agreement or amending an annex, as it is called here. And this is actually the only place in the agreement where homogeneity in this form is mentioned. There is two places where there's a discussion about the homogeneous area. But I think that is worth taking into consideration. Now, the EEA relevant labeling, I don't take that too seriously, to be honest. And I've seen some people reading into Article 102 that only acts that are governed by the agreement should be incorporated, but that is not my understanding from Article 102. What is meant here is that when the EU side is adopting an act that is governed by the agreement, they should inform the contracting parties. That is the main message of that text. And then what is probably also most important here is that an annex directly affected by the new legislation is assessed by the Joint Committee, who should make every effort to find a mutually acceptable solution. Well, my point here is that I think the message is clear. There is a flexibility in this article for sure, even if granted not everything goes. But I did find it also relevant, taking into consideration where we are geographically, to also cite here the Osbald case. It's a good reminder, a case decided by the Court of Justice and has also been referred to by the EFTA Court, where the court says that the EEA agreement aims for the fullest possible realization of the free movement of goods, persons, services, and capital, so that the internal market established within the European Union is extended to the EFTA states. So that is the essence of what we are dealing with, and it's fine to be reminded from time to time. I will come back a little bit to these extensions, and now we are entering into something we can call academic animations. This is not all appearing at the same time. I'm here mentioning not to criticize or to analyze, simply examples of the flexibility of the EEA agreement. One is the emission trading scheme that was certainly not considered to fall within the scope of the agreement in the first instance, but was made as a part of the annex. The solution as concerning the European Aviation Surveillance Agency, I was actually quite pleased when there was a decision from that agency grounding the MAX 8 airplanes in Iceland, because that had not been the intention of Icelandair. But there was a decision coming from that agency, and to my, not surprise, but it was pleasing, it was a decision that was immediately effective in Iceland without being incorporated directly into the EEA agreement, something we call one-pillar solution. Then we had some genius decisions it was in 1999 where the first sort of solution of this type came, the European Medicinal Control Agency and marketing authorization for medicinal products. When such decisions are taken by the European Commission, the EFTA states should simultaneously take nationally corresponding decisions. So this is also a type of, I say, 1.5 pillar. I don't know what the experts say about that. And then we had GDPR. Well, that is filled with interesting solutions. I'm not going to dwell on that, but obviously there is here, one could say, an exception from Article 102. EFTA states are to apply implementing acts regarding adequacy decisions pending decisions of the Joint Committee. So that is a creative solution. Then the ESAs, as already mentioned, I think that was a very creative and in many respects a good solution. I know my friend Halvard has a lot of reservations. Now, having had to, which is good for an academic, I spent 3 years in ESA and had to implement this on behalf of the EFTA Surveillance Authority, which was perhaps reasonable. I think this is a good story of something which is possible to achieve. But of course, it meant and means that in this case, the Surveillance Authority really has to do the work properly and put effort into making this work, and that is the relationship with the European financial supervisory agencies. Then comes the Paris Agreement through EU regulations incorporated in Protocol 31. Is this a program? I don't know. I don't think so. What comes with it is also surveillance, surprisingly, or there is responsibility for the EFTA Surveillance Authority, so you incorporate institutional provisions of the EEA agreement in Protocol 31. I think that is also creative. The most recent examples have been alluded to here earlier, those that relate to defense industry related issues. There, at least, you could say some of those are indeed programs, but these are only applicable to Norway, so they are, well, I'm not saying bilateral, but they're only for Norway. What is bilateral is the EU-Norway Security Defence Partnership of May 2024. That is an interesting partnership and agreement where it is, for example, mentioned that Norway is a key and valuable player in the common defence and security policy. I'm sure they are. But in this text, there is a significant references to the EEA agreement and the possibilities Norway has to actually participate in defense industrial related issues through the Protocol 31 and the so-called programs. So this is just a snapshot of different things that are indeed possible when you really want to keep the agreement alive. There are then the sort of main two entrances, that is Article 102, and then through Protocol 31 via Article 77 and 78. But that's not all. That is not all. Actually, this was not supposed to happen like this. Okay, anyway. I will come to this case towards the end. The homogeneity of the EEA is not only secured through these amendments to the EEA agreement, but has also been preserved by the EFTA Court in particular, who noted already in 2016 this gap that I mentioned here in the beginning, and that the gap has widened over the years. And I would say the court has shouldered the responsibility to mend the gap as much as possible, has of course been criticized for that sometimes, but these are crucial decisions I would like to maintain. And already here, Pascal was mentioning the Citizenship Directive. Of course, it was cleaned in the Joint Committee of references to the, let's say at least, the concept and the citizenship provisions of the European Union. That, however, even that is a very political endeavor. It is also very much about free movement, and that is something that the EFTA Court has taken seriously and interpreted the Citizenship Directive differently, as the court said recently, to make sure that the Citizenship Directive, I guess one could say, is used to compensate for some of the things that you have otherwise not incorporated due to the lack of the citizenship provisions. Now this has been mainly in Norway that has been criticizing or challenging this line of decisions taken by the EFTA Court and has attempted a couple of rematches even before the Court of Justice in Luxembourg. But this line of cases is indeed interesting. I can of course not go into this in detail, but in a recent decision of the Norwegian Supreme Court, I would say this matter is, from the viewpoint of, you will correct me, Halvard, viewpoint of Norwegian law, hopefully somewhat more settled now. Now, fundamental rights and the EU Charter of Fundamental Rights. I could, of course, spend the whole day talking about this. I would try to resist. Interpretation is the starting point. That was what the court said in the Pétursson case. It was extremely important that the EFTA court took this evolution of fundamental rights protection that we had seen in EU law also to be a part of the EEA agreement, even if the agreement is otherwise almost silent on fundamental rights. And that was done initially by way of stating that the EEA agreement and the ESA court agreement are to be interpreted in light of fundamental rights, where the European Convention of Human Rights is the most important source. So that was the first stage. Now we have had many subsequent stages where fundamental rights are playing an important role in interpreting, for example, and applying EU EEA secondary norms, and also when relying on free movement provisions for justification. Now, what has been happening since 2009, where the EU Charter of Fundamental Rights became legally binding on the EU side, is how should the EEA legal order deal with that? Now, the easiest way would have been to somehow incorporate that agreement or charter into the EEA agreement. That has not been done. It may probably also be easier said than done. But the EFTA court has, I would say that the first sort of sign was in the Olsen case, where you could see a text in the ruling which was more or less identical to Article 52.1 of the EU Charter of Fundamental Rights on limitation of fundamental rights. It was, and that is of course one way of incorporating the Charter, namely simply to take the text and repeat that in the rulings, but perhaps not a sufficient way. Interestingly, in the case here, TCAA, that is here appearing involuntarily here on the slide, paragraph 82, the court basically did what the court did in Olsen, but they fixed a minor issue, which I think they omitted in Olsen. So you have now, in the ruling of the court in that case, more or less a verbatim replication of Article 52.1 concerning limitations of fundamental rights. So that is welcomed from my point of view. Now, I mentioned here the LDL case. For full disclosure, I was an ad hoc judge in the case, but that's also a demonstration of the fact that the court also has to deal with the methodological implications that come with the Charter. The Charter is impacting EU law also in terms of methodology, in my view. And that is reflected in that ruling. So it's not only mirroring completely Nordic info, because by doing that you are also have to accept certain methodological evolutions that are taking place on the EU side related to the Charter. Also there in that case demonstrates how fundamental rights can play a role on sort of two opposite sides on when limitation of free movement is taking place, namely the obligation of the states to protect health, public health, Article 2, and also privacy considerations on the other end. So you can see you can have application of balancing in that test. Now, another interesting case came in December last year, where the EFTA court said that the Charter could be a foundation or part of the legal sources that can form the foundation for a general principle of EU law, that here is the protection of the child. So you can see that the Charter is slowly, indirectly at least, making its way into EEA law. I think the most significant development came last week. I really need to control myself now not to spend too much time on this. But there is this paragraph, and this case was about the fact as whether, well, it was about the question about the interpretation of a directive that partly had been annulled on the EU side through the Luxembourg business registry case, and it had been annulled on the basis of the EU Charter. So it was not any annulment. How should the EFTA Court deal with that? It's quite clear that this should have been a responsibility of the Joint Committee, and I fail to understand why the Joint Committee had not amended the agreement. They had ample of time to do that, but since they had not done that at the point of time when the case came to the EFTA Court is faced with this difficult task, I would like to say. Should the court pronounce itself and interpret a text of a directive that has been annulled on the basis of fundamental rights? I think that is an impossible task, a really difficult task, at least. How the court dealt with that was to, first of all, in a long text, I only take part of it, explain the fundamental rights rationale of EEA law, and moreover here saying for the first time explicitly that the Charter may likewise be relevant in the interpretation of EEA law. I would say it has not been said as explicitly before. Now, what does interpretation mean? I will ask you to look again to the Pétursson case. The first step was interpretation, but interpretation can mean actually quite a lot. And we could see that already in this case, because in paragraph 58, the court said that through interpretation, the court would more or less get rid of this contested part of the directive that had already been made void and annulled under EU law. So this is, in my view, a de facto annulment, but it is neatly done through interpretation. I cannot spend more time on this now. I have to stop. I think there was not many other ways actually for the court but to acknowledge that this had been annulled. Maybe this can also supplement should the now this is just for the fundamental rights nerds in this room. Are there any apart from myself? Yes. For the hopefully new revision of the Strasbourg Court of the Bosphorus presumption, if that should be granted also to the EEA legal order, I think this case should at least, as a minimum, supplement that. Now, it has been said many, many times here today that EEA law is becoming increasingly complicated. I just wanted to mention here that EEA is not only something for the EEA-EFTA states. We also have to be mindful of the parameters that come with EU law and from EU constitutional law. So even if we are eager to draft different one or two pillar solutions to accommodate the evolving EU law structures and decentralizations, there are limitations, and they can also come from the EU constitutional framework. I mentioned here the Moroni Doctrine. I'm not saying that it has been breached, but that is one of the things that, for example, impact the responsibilities that you can give to agencies, also in the EEA context, I would like to maintain. And then the Charter of Fundamental Rights. Not everything goes. Not every joint committee solution is necessarily, well, I'm not saying it is not, but it's not necessarily compliant with the Charter, for example, if access to justice is restricted. You may think that the question will never reach the Court of Justice, but I think the Ruska Federacja case, the Iron case, demonstrates to us that, yes, indeed, EEA law, even the main part of the agreement, may in certain circumstances be interpreted in the light of the EU Charter, as we saw in that case, among many other interesting things. So, time is still okay. Good. I'm now reaching the third pillar, and I'm saying here, first of all, that through the EEA agreement, from the viewpoint of Iceland, and I know for sure from the viewpoint of Norway, I'm not so certain about Liechtenstein, I did put it here, but I will then stand corrected, that indeed through the EEA agreement in these 30 years, we have seen, because of the EEA agreement, some interesting constitutional interpretations or interpretations by the courts at the highest level, where the EEA agreement has been pushing the constitutional development. For Norway, I know, for example, we saw, well, there's been these questions about the transfer framework of the constitution, and also we saw 3-4 years ago, was it maybe 5 years ago, the Parliament asking the Supreme Court for an advisory opinion, something that had not happened at least for many years, if ever before. One of the main challenges we have in Iceland when it comes to the EEA agreement is the fact that there is no explicit written constitutional provisions on transfer of state power. The constitution is more or less silent on that. But there is an unwritten principle, if you like, that on the basis of which we have acceded to the EEA agreement. Iceland has done different things, NATO accession, to name one, Schengen, etc., etc. But we lack an explicit provision, as we have, for example, in Norway and other Nordic countries I know. Would have been helpful to have it, because nowadays every, let's say, third energy package or whatever, every case where the question comes up becomes extremely sensitive and political, and then the politicians end every sort of debate by asking the academics, what is the rule, what is the ambit of the rule, and I think that's the worst way of working. But that's how it is. So this is one of the challenges that remains, and I will come back to that. Protocol 35, some of you know about that story. It was implemented, or there was an attempt to implement that already when the agreement was entering into force. Supreme Court was playing along, and in the first rulings, it actually granted a priority to EEA norms with a reference to the implementing act. But then, interestingly, the composition of the court changed, and gradually the court stopped playing along and eventually said that, or implicitly said that they could not grant any such priority to EEA norms. And this caused numerous problems. Some of the problems quite serious, I would like to maintain. One of the problems is that this has meant fewer references and has actually meant that EEA norms have been suppressed way too much in the Icelandic legal order. Hopefully this will be fixed. There is a proposal. The first reading is over. Hopefully we will see a new act in the spring. Let's see. There have also been very interesting recent Supreme Court rulings which show a very positive sign, I would like to say, talking about the composition of the Supreme Court. Now this is a different court from the court that actually rejected Protocol 35. I would say rather more positive. In the Einarsdóttir case, that actually case that had been sent to the EFTA court, yes, the Supreme Court did not grant Ms. Einarsdóttir her parental leave payments, but there was a very rich obiter dictum in that ruling, where for the first time the court was a full court, complete court with 7 judges, and also the court was discussing in a specific chapter the relationship between EEA law and national law in a very, I would say, EEA-friendly manner, at the same time implicitly endorsing the Amendment Act of Protocol 35 and explicitly saying that Protocol 35 had not been correctly implemented in EEA law. That would obviously make any references then to the EFTA court to ask that question unnecessary. Another case is the Sverrisson case, Working Time Directive case that had already been in the EFTA court. I'm not going to go into detail here, but just to mention those of you who know the Björn and Kula case, consistent interpretation, where the Court of Justice made quite far-reaching statements about how one should not look into preparatory work when interpreting directives. And that was actually what the Icelandic Supreme Court said in this case. One should not look at the preparatory work and use that to interpret the national law that was based on the directive. This is a huge step for a Scandinavian legal order, where preparatory works are normally playing a really important role in interpretation of rules. Now, final point here before I go to my final slide, EU accession of Iceland. Is that what you are all waiting for? I don't know. This will be a lot of speculations, of course, but some of you may know that Iceland applied in 2009. First of all, this came from the Parliament, an application to EU to become a candidate country, initiate the procedures. The answer came 11 months later, 17th of June 2010, actually the Icelandic National Day. Maybe they could have picked another day, but that's another story. The Council approved, and Iceland became a candidate country, and the discussion started. Now, this is a very sad story, I have to admit, from my point of view. That is the accession discussions and the accession process. Certainly, Iceland was to be blamed for some things, but this is an impossible process for many different reasons. One of the reasons is that bilateral interventions are extremely easy. So one country, due to discussions about mackerel, a migrating fish stock, can hold up the discussions forever and ever. This is actually ridiculous. And this is one of the reasons that the previous discussions, they dragged on and dragged on and dragged on and dragged on. So gradually the support for EU accession evaporated. And also there was a change in government. And the Minister for Foreign Affairs sent a letter in 2015 to Brussels, said Iceland does not want to participate in the accession discussions anymore. And EU didn't say more. Then came another letter from Iceland saying Iceland does not want to be considered a candidate country anymore. And then the Commission said, we take note. And they appropriately put the discussions on ice, where they have been for many years. And recently the Commission maintained and said that, well, you have not withdrawn your application. We can reopen. And that will mean that the accession discussions can start more easily than before. I think, of course, some of the discussions or chapters that were closed may have to be reopened. But I'm hopeful, even if I have no clue, that the EU has done a bit of their own homework, and for me, a country that has been a member of the internal market for 30 years and been subject to the institutional structure of the EEA agreement, is a NATO member, what more have you. I think the discussion should not have to take 5, 6, 7, 8 years. I find that problematic, and I fail to understand why. Anyway, what will happen? Nobody really knows, but what we know is the current government has explicitly said that no later than 2027, there will be a new referendum, and the referendum will be on as whether we should restart the discussion. Maybe you want to know the polls. Clear majority at the moment for reopening the discussions from the polls. 54% in favor, I think about 20% who don't care, and 30% who are against, more or less. Now, will they start these discussions earlier? I don't know. But what the Prime Minister said this morning, that's why I brought the phone to the podium here. So the heading says, it's not on the agenda to push forward the referendum on EU accession. And there's a picture of the Prime Minister. And I said, okay, that's quite strong wording, because the government has said it's no later than 27. It hasn't really set the date. But then when I was reading the actual news, which is then sometimes helpful, it turns out that she doesn't say that explicitly. She says there has been no decision taken to push forward the decision or the referendum on the decision on the referendum. So I don't know. You can read into this as much as I can. This will happen no later than 2027. Will it happen in 2026? I don't know. Will it happen in 2025? I don't think so. Will it happen in 2027? Yes. So that's more or less as clear answers I can give you. So now it is for me to wrap it up. I'm still good with time? Okay. I don't know if I have to say so, but of course, my outlook and overview was not exhaustive. I'm simply saying, when you are entering into these discussions about the boundaries of EEA, from my point of view, you need to address these issues. There is a lot that can be said more about each of these sort of two pillars. But I thought here, towards the end, I would speculate a bit. What can you do in the current situation? Well, you can do nothing, if that is a strategy. And you can do something too late. And this is actually one of the things that are bothering me quite a lot. I find significant acts not being incorporated timely enough, and I think that is a real problem. I mentioned the AI Act, for example. Why is that not already part of the EEA agreement in operation? I don't understand that. And this is a per se risk. Especially when you know and you can see that there are no constitutional problems, really. There are some problems, but we have to follow. There are things that are happening so fast, especially when it comes to security. And I mean, security is an elusive concept. It can mean national security, it can mean public security, it can mean international security, actually mentioned in the EEA agreement. And it can mean economic security. And each of these security terms has competences implications, indeed. But that is the reality. Now, I went off track a bit. I'm anti-agreement. It's not very realistic. We all know that. It's not going to happen. Accede to the EU. Yes, that's a solution. But we also realize that that route is not necessarily clear either. And then we come back to use the EEA agreement in a creative and flexible way. Yes, I think that must be the best solution. And that is what we have, that is what we know. And we can see, and I demonstrated what can be done both via Classic 102 and or Protocol 31. A lot of things can be done. Now, I want to mention also, if these solutions are not working, there is this, what I would like to call, this special relationship. So in the IN case, and I have to admit, and I still have 2 minutes, I was working for the After Surveillance Authority at the time, very much involved in the case, and drafting the pleadings. I was constantly putting in something called mutual trust. I was hoping that Kuhn Lennartz would actually jump on that and we could get that as part of the EEA legal order. Didn't happen. What we got was the special relationship. I'm not saying it's the same, but it's always nice to be called special. And there are, in 2 circumstances, if you read that case, where you have the special relationship. Special relationship is between the EU and the EEA. But there is also a special relationship that is connected to the EEA countries having also separate bilateral arrangements. It's not explicitly the same as the special relationship EU and the EEA legal order have through the agreements, but this is, and that's why I would like to call it this special relationship. And I think that is something we have to consider. And I think that is a possible alternative in some of the challenges that we have to create either a bundle of acts or a specific agreement in a multilateral arrangement with the European Union, taking on these acts and filling in more into this special relationship. And to make it special relationship, I suggest that enforcement, surveillance, and access to justice is added in these type of agreements. We have all the possibilities to do so. We can see it in the UK EEA separation agreement. We can see from the from the EFTA court itself, explicitly commenting on that to add that to, for example, Schengen, Dublin, and the surrender agreements, Lugano. And I think that would make as one alternative possible and good solution if we are unable to amend the annexes to the EEA agreement. I will stop here. Thank you so much.
Thank you very much, Gunnar Thor. This was very helpful and timely and already taking a lot away from what others will have to say, probably on the same issue. And we hopefully now hear a variation of this from a Norwegian point of view. Please, Halvard.